All right, we are on the record in State of Idaho versus Braxton Adams, CR 1019-11391, CR 1023-9438, CR 1023-5070, CR 1024-1570. State is present, represented by Jeffrey Thomason. Mr. Adams is present along with his attorney Paul Butekofer. We're here for sentencing in case 235070 and 241570, and disposition in case 19-11391. Mr. Butekofer, are we proceeding with those matters today?
Yes, Your Honor.
All right. Mr. Adams, before I turn it over to the attorneys for comment, I just want to go through a little bit of the procedural history of the two cases for which you are here for sentencing. In case 235070, you were first arraigned before me October 2nd, 2023. At that time, you'd been advised that you had been charged with children, lewd conduct with a child under the age of 16 years. You pled not guilty to that charge. And in case 241570, you came before me on April 1, 2024, advised you'd been charged with the grand theft. On April 1st, you actually pled guilty to that grand theft as part of the plea agreement. And at that time, you also pled guilty to an amended charge in case 235070 of injury to child in violation of Idaho Code section 18-1501, subparagraph 1. As part of that plea agreement, the state agreed it would dismiss all charges in case 239438. The state also agreed that it would recommend a sentence consistent with the pre-sentence investigation, no worse than a retained jurisdiction. There was also an agreement that you would apply to a specialty court, or the state might recommend a specialty court along with probation if that was appropriate. You agreed to pay full restitution on the cases, including those charges that were dismissed. You reserved your right to be free to argue what an appropriate sentence should be in these cases. You also agreed to admit to probation violations in case 19-11391, and you did in fact admit to those probation violations on April 1st. The plea agreement you reached with the state was not binding on the court, and following that plea agreement, I ordered a pre-sentence investigation report be prepared. One was prepared, and now I'm trying to find it. There it is. And that report was filed May 22nd, 2024. Mr. Adams, have you had an opportunity to review that report?
Yes, Your Honor.
Mr. Butekofer, anything in that report that needs to be corrected or clarified?
No, Your Honor.
Any objection to me relying on that report for purposes of sentencing?
No, Your Honor.
Mr. Adams, do you intend to stand by the guilty pleas you previously entered?
Yes, Your Honor.
All right. Then with that, Mr. Thompson, are there any witnesses or victim impact statements that want to proceed at this time?
No, Your Honor.
All right. With that, Mr. Butekofer, I'll turn it over to you for comment and recommendation.
Okay, Your Honor, before I do that, may I call a witness,
You may.
Kevin Brierline? Brierline.
Byerline. Mr. Byerline, come on up.
Okay.
Go ahead and stand in the well. Raise your right hand. My clerk will place you under oath.
Do you solemnly swear that the testimony you're about to give in this pending cause shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Go ahead and have a seat. Make sure you're comfortable. Get that mic close enough and just speak loudly enough that we can keep an accurate record. Go ahead, Mr. Butekofer.
Could you please state your name and spell your last?
Yes, it's Kevin Byerline, Beyerlein.
And how are you employed, sir?
I work for a company called One Love. I work a PHP, IOP, an outpatient program. I'm the director or manager of that program.
Do you know Braxton Adams?
I do not know him personally. Just been working through the court system, trying to help him where I can.
Okay, what contact have you had with him?
I've had contact through the courts giving us information and through his friends.
And what program did you say you work?
I work the PHP, which is the Partial Hospitalization Program. It's for drug and alcohol and mental health. It's a dual diagnosis program.
Is Mr. Adams accepted into that program?
He is, yes.
And when did that acceptance happen?
That happens as soon as, anytime we will accept him as soon as the court allows it.
Okay, so he's been screened and accepted.
Yeah, we'll screen him for assessment after he comes into our program. And so,
And what sort of services do you provide besides drug and alcohol?
yeah, we will provide therapy, one-on-one sessions. We'll provide case management. We can provide psych testing. I'm also what's called a psychological tester. I work with a doctor named Dr. Harris. He does the primary, I do the testing, and then together we write a report that will help with any kind of psychological needs or any kind of, we also look at the drug and alcohol part of it too. We'll also do assessments for like the ASAM or the locus, whichever one we determine is more the ASAMs for drug and alcohol, or the locus is for the mental health. We'll also do a CDA, which is the cognitive, an assessment for his cognitive and diagnostics.
What about housing?
Housing, we don't have any housing at this moment, but we can help him find housing. That's why we have case management. We have a case manager and myself that look around and try to find the best place for him and where we can help him. Sometimes we can get him into the rescue mission and or other places that will accept him into that program.
So if the court were to place Mr. Adams on probation, what's your timeline as far as getting housing and everything set up?
Yeah, we'll work on it immediately, like right away. As soon as he comes into the program, we'll get him assessed. We'll have our case manager work on it right away and start calling around and get him interviews and get him to the places where we can hopefully get him accepted.
So would he do that? Would he have to be released to do that, or could you start that if the court grants probation while he's in custody? And then once you have everything set up, he could go into that
Yes, we could do that for sure. Yep.
in custody?
Yes, in custody. Yes.
That's all the questions I have, Judge.
All right, thank you. Mr. Thompson, any questions of Mr. Byronlin?
No, Your Honor, I don't have any questions, Mr. Byron.
Okay, thank you. You may step down.
Thank you.
All right. Mr. Peacock, any other witnesses?
No, Your Honor.
All right, I will take that into consideration as we proceed today. You may go ahead with comment and recommendation.
So, Your Honor, Mr. Adams is 38 years old. The pre-sentence investigation recommends a rider. He did do a rider in, I believe, 2020. But as the court is aware, that was a COVID rider. The plea agreement, as the court stated, is consistent with the PSI, but no worse than a rider. His LSI is 38, places him in the high category. He had a number of mental health issues as outlined in the pre-sentence investigation. He started, well, let me just start with the injury to child charge that he pled to was 2018. So it's been 6 years ago. In the PSI, Mr. Adams expressed remorse. He also expressed that he feels horrible about his victims. He has been successful on probation before. He's got support. His dad's in the courtroom today supporting him. He started drinking at 14, then it turned to marijuana and methamphetamine use at that same age. He has employable skills. He's a journeyman, licensed, 11 years, works with the union He's never lived outside Idaho, so he has ties to Idaho. His PSE said that he was at a low risk to reoffend, and he would really like an opportunity on probation. So we're asking the court to impose a 3+3 suspended and give him a shot with one love and stay in custody until he can be released once he's got housing set up and start that program.
All right, thank you, Mr. Butekofer. Mr. Thompson, comment, recommendation from the state?
Yes, Your Honor. The state is, the recommendation that in the plea agreement was that the state would recommend a recommendation consistent with the pre-sentence investigation, no worse than Ryder. The pre-sentence investigation is recommending retained jurisdiction. We would be asking for an underlying sentence of 3 years fixed and 7 years indeterminate. As I reviewed the defendant's PSI, psychosexual evaluation, the defendant's LSI scores, Mr. Butekofer indicated, is a 38, putting him in that high-risk category to reoffend. Mr. Adams indicates in the PSI in regards to the injury to child charge, he says, I touched a child in which caused mental anguish. I feel very bad. I harmed the victim and caused mental problems for the victim. I wish I could take back the crime. I want to stay in recovery to help maintain my sobriety. And so there is some admissions in regards to the crime of the injured child, obviously where he has pled guilty to that. But it appears that there was Mr. Adams is refusing to admit to any sexual contact, that harmful touching involved in sexual contact in nature, and which also caused some issues for in the psychosexual evaluation, as the evaluator was unable to recommend any sexual offender treatment based on his denial of the claims of sexual contact. As the state's continued review by the defendant's PSI in regards to criminal history, the defendant has a very lengthy criminal history. He's been on probation many times in the past. He was first convicted, I believe, of attempted possession of a controlled substance and injury injury to jail in 2005. He was sentenced to supervised probation, successfully completed that probation in July of 2008. He was then convicted of manufacturing controlled substance in 2016. He was again put on probation, successfully completed that probation without violation in February 2018, and even earned an early discharge from probation. Mr. Adams was next convicted of felonies of injury to property and fleeing or attempting to elude a police officer in June of 2020. He was then sentenced to a retained jurisdiction. And was released back to probation in April of 2021. He was first arrested on the instant offense, in this case injury to child, around June of 2023. He served about a month in jail before he bonded out. And in October of 2023, he was returned back to the Bottom County Jail on a new burglary charge, and was released again about a month later. And then in February of 2024, he was arrested on the second of the instant offenses, being the grand theft. And he's been in custody since then. When the investigator asked Mr. Adams what had contributed to his criminal behavior, he stated that it was methamphetamine and fentanyl, along with drug-induced schizophrenia is what caused him to commit the crimes. And so he has attempted to address some of those issues with certain steps for treatment. But he indicated to the investigator he's got a desire to complete treatment. But he is, his last report of violation, he was given multiple opportunities to engage in treatment but failed to complete those treatment objectives in 1 year. And so, and this is even confirmed, his drug addiction issues were even confirmed in the psychosexual evaluation that recommended substance abuse treatment. But it's the state's position, and as well as the investigator's position, that probation would be appropriate for Mr. Adams due to the difficulty of supervising him in the community. He's committed a litany of offenses in such a short period of time that seems to be driven by substance abuse. And so given that, the state recommends that there's a higher level of structure involved in treatment for Mr. Adams. That being, of course, a retained jurisdiction. So that would be what the state is recommending in this case, Your Honor, would be, it's going to be sentenced to retained jurisdiction with a fixed determined time of 3 years and an indeterminate time of 7 years. Thank you.
Thank you, Mr. Thompson. Mr. Adams, you have an opportunity to directly make a statement to me. You don't have to make any statement at all. There is no negative meaning or inference that I place on any defendant that chooses to remain silent at this stage of the process. But if you want to make a statement, I would just ask that you speak clearly and loudly enough into that microphone so that we get an accurate record. Do you want to make a statement?
Yeah, I take full accountability for my actions, Your Honor, and very remorseful. I can successfully complete treatment. I've successfully completed drug court before. And that's the best I've ever done in my life, and I look forward to staying sober. I've been sober since February, so I got a good jump start on the sober part. I just want to ask for the treatment so I can get better. Thank you.
All right, thank you for those comments. Are you fully satisfied with the representation Mr. Butekoffer has provided?
Yes, I am.
Mr. Butekoffer, any legal reason I should not impose sentence today?
No, Your Honor.
And with that, Mr. Adams, based on your previous pleas of guilty, it is a judgment of this court that in CR 10-23-50-70, you are guilty of the crime of children, injury to child, in violation of Idaho Code 18-1501, subparentheses 1. In case CR 10-24-15-70, you are guilty of grand theft. In preparation of today, I went back and I looked at the entirety of your files. It includes the pre-sentence investigation report, that also includes a psychosexual evaluation that was prepared as part of that report. I've also looked at other matters, including the probation violation case and that underlying case and your history in those cases. For any sentencing, I must keep in mind the objectives of sentencing that have been outlined by the Idaho Supreme Court. Those objectives include punishment, rehabilitation, protection of society, and deterrence for you and others. I also reviewed the Code Section 19-2521. That's a code section that outlines reasons why a court would or would not place someone on probation or why it would impose incarceration. With all of those factors in mind, I do want to make some comments that went into my decision, some of which have been noted by your attorney, yourself, and the state. The PSI does recommend a retained jurisdiction would be an appropriate sentence. It does note your age, you're 38 years of age and your LSI is 38, which is high. As I explained to all individuals who come before me, that LSI number is an important number to this court, to probation and parole, and to the Idaho Department of Corrections. It is an actuarial table comprised of 8 different categories. There is a statistical correlation between that number and whether the likelihood that somebody might commit a crime in the future. The higher that number climbs, the more likely it is that somebody would commit a crime in the future. You're in that high category. Obviously, that does not bode well for you. The good news is that all individuals have an opportunity to work on those different categories to drive that number down. As an example, one category is your criminal history. Well, it is what it is. That can't change. You can prevent it from getting higher. You can't make it go any lower. Another category of concern is companions. It's pretty self-explanatory. If you are hanging out with individuals that are committing crimes, you are more likely to commit crimes yourself. That is a category that you can work on. Emotional, personal, that has to do with some of the things that were revealed and reviewed with respect to your mental health issues and those sorts of things. If you don't address those and take care of those through appropriate programming and treatment, then that will cause you problems in the future. I always want to just take a couple of moments to explain what that is, because that number is going to come up in your future. And you then maybe at least can understand why it's important to all of the entities that will be involved with your life in the foreseeable future. There are any number of aggravating factors that went into my decision. As indicated by the state, you took responsibility for your actions, but you denied that any of your contact with the victims was of a sexual nature. You do have a significant criminal history, including 5 previous felony convictions. Your probation officer has recommended that I revoke your probation as part of that probation violation. There's early drug and alcohol use, as was outlined by Mr. Butikoffer, specifically alcohol at the age of 14, marijuana, meth, cocaine at the age of 14, reported daily use of all of those, including fentanyl was thrown in there. But you have, as a mitigating factor, you have indicated that your last use was in February. So as you yourself indicated, you have several months of sobriety behind you, and congratulations to you, that's important. There were some treatment programs that you did not complete. There was noted here regarding a summary from Moonlight Mountain Recovery in January of this year that you did not complete their outpatient program. You were denied admission to a treatment court. You did make an application, you were denied into that treatment court. But as an aggravating factor, I am taking into consideration Mr. Byerland's testimony that if I place you on probation, that you would be accepted into the One Love program, of which this court is very familiar for treatment purposes. There are other mitigating factors this court noted. And this is a mitigating and an aggravating factor. You've already served for retained jurisdiction, as your attorney pointed out, what we'd like to call a COVID retained jurisdiction. This court understands that the programming was not as good during COVID just because you just didn't have the ability to attend to the matters the same way we do when we're in person. You do have high school education plus technical training. You have very employable skills. You have completed prior programming, and you have completed prior terms of probation successfully as you've gone through these processes. So, see if I had any other notes. Your PSE did indicate that with respect to other potential sexual related crimes, your risk level is low. There is some concerns coming from the PSE, as noted by the state, that you weren't fully accepting that your contact with the individuals was sexual in nature, and that the evaluator just noted that that could create problems for purposes of a treatment program. However, despite that, or in spite of that, the risk level of another offense is low, and you are low risk to reoffend in the future for any similar crimes. That being said, Mr. Adams, it is the Judgment of this court that you be sentenced to the Idaho Department of Corrections as follows. In case CR 10-23-50-73, that's the injury to child, you be sentenced to a 3-year determinate period of time followed by a 7-year indeterminate period of time. In case CR 10-24-15-70, that is the grand theft, you be sentenced to the Idaho Department of Corrections for a 2-year determinate period of time followed by a 3-year indeterminate period of time. Those cases will run concurrent. They will also run concurrent with case CR 10-19-11391. I have to look at the factors and given all the circumstances, your history, given the nature of the offenses, I am going to impose those sentences, Mr. Adams. I believe the lesser sentence reduces the severity of the crimes. It ignores your history. You have multiple convictions, so I am going to impose those sentences. Fines, in case 23-50-70, $2,000 fine. In case 24-15-70, $1,000 fine. I'm imposing a $2,000 civil penalty under Idaho Code 1953-07 in case 23-50-70. There will be reimbursement to the county for public defender services in the amount of $500. Do you have any questions regarding the sentence I've imposed?
No, Your Honor.
Mr. Biedekofer, anything I need to correct, clarify, or I failed to address?
No, Your Honor.
Mr. Thomason?
No, Your Honor.
All right.
Is that $250 in each case or $500 in each case?
$250 in each case. All right. Mr. Adams, in case CR 10-19-11391, you're here for a disposition on a probation violation. You admitted probation violations, and I find with your conviction today that also is a violation of your probation. Those violations are material. They are material enough for me to revoke those probations and impose the sentence in that case. The underlying sentence in that case was a 2-year determinate plus a 3-year indeterminate. You've already served some of that time, including the retained jurisdiction that you've already served. That sentence will run concurrent with the other 2 that I've imposed. Do you have any questions regarding the disposition in that case?
No, Your Honor.
All right, Mr. Adams, you now have the right to appeal.
There's no contact order.
No. There is no contact order in case 23-50-70. That no contact order will be extended for 10 years, Mr. Adams. It's the entirety of your sentence. I will advise you that the victim will have an opportunity to file an application with the court to extend that farther, but if there's no application, it will expire at the end of 10 years. Do you understand that?
I do.
Now, Mr. Adams, you have the right to appeal the decisions of this court. You have 42 days to file that appeal. You also have the right to seek relief under Idaho Criminal Rule 35 if you think my decision is illegal or too harsh. In case 23-50-70, you have 120 days to seek relief under that act. And in case, let me go back. In case 50-70 and 24-15-70, you have 120 days to seek relief under Idaho Criminal Rule 35. In the case 19-11391, because that's a probation violation, you only have 14 days to seek that relief. You can always seek relief under the Idaho Uniform Post-Conviction Relief Act. You have 1 year after your appellate rights expire to seek relief under that act. You have a right to have an attorney assist with those appeals, and if you cannot afford one would be appointed. You understand your appellate rights?
I do.
Do you have any questions of me regarding the sentence I've imposed or your appellate rights?
No, Your Honor.
And with that, I will remand you back to the Bonneville County Sheriff. He will eventually turn you over to the Idaho Department of Corrections to serve that sentence. And with that, I wish you luck and you are excused. We are in recess. Thank you.